Sandra never called a lawyer. She was driving home from her shift from the grocery store in Fairmont one evening when a pickup truck blew a stop sign and hit her in the driver's side door. Her car accident settlement in West Virginia ended at $4,200, enough to cover just about 1 month's rent and a week of lost wages. She thought it was fair. The adjuster told her it was standard, but it wasn't. Her injuries, a herniated disc and nerve damage in her shoulder, showed up 6 weeks later, but by then, she'd already signed the release. There was nothing anyone could do for her. I'm Tim Miley, and I'm a personal injury lawyer right here in West Virginia. In this video, I'm going to show you exactly why insurance companies love operating in West Virginia, and I mean specifically in this state for specific reasons. And before we're done, I'm going to tell you something about your body in the hours and days after a crash that insurance adjusters already know, and they're betting that you don't. West Virginia settlements run low. Here's why that's not an accident. Here's the truth. While no statewide data set tracks average settlements, attorneys across the region consistently report that West Virginia settlements tend to run lower than our neighboring states like Virginia or Pennsylvania. It's a pattern that anyone in personal injury law in this state can tell you about firsthand. Insurance companies know about it. They track settlement data by state, by county, and by jurisdiction. They know what cases settle for in Harrison County, West Virginia, versus what they settle for in Allegheny County in Pennsylvania. That data shapes how their adjusters operate. When an adjuster calls you from some regional office in Columbus or Richmond, they already know the number they're working toward, and it's lower for West Virginia than it would be for most other states. Why? Several reasons, and I'm going to walk through each one with you. Poverty rates and the pressure to settle fast. West Virginia is one of the poorest states in the country. The median household income sits well below the national average. When you've got rent due, when you're missing work because your car is totaled, when you've got medical bills arriving before your body is even healed, the pressure to take whatever the insurance company offers is enormous. Insurance adjusters are trained to call early, not because they want to help you, because they want to reach you before you understand what your case is actually worth. They want to reach you while you're scared, while you're hurting, while your focus is on survival, not on justice. Now here's what most people don't realize. The goal of that first call is not to evaluate your claim fairly. The goal is to get you to agree to something before you talk to anyone who can tell you what you're actually entitled to. In wealthier states with stronger safety nets, people can hold out longer. But in West Virginia, too many people can't. The insurance companies know that. In fact, they count on it. Here's another factor that works in the insurance company's favor. In a lot of West Virginia, access to a personal injury attorney isn't easy. If you're in Charleston or Morgantown, you've got options within a reasonable drive. But if you're out in Calhoun County, Wirt County, Nicholas County, the practical reality is that many injured people never talk to a lawyer. Either they don't know their rights, they don't know attorneys work on contingency and cost nothing up front, or they assume a lawyer won't take their case. Insurance companies don't have this problem. They have legal departments, claims adjusters, and institutional knowledge working for them around the clock. The injured person in rural West Virginia often has none of that on their side. The less access people have to legal counsel, the lower settlements run. It's that direct of a relationship. Modified comparative fault, the blame-shifting tool. West Virginia uses what's called a modified comparative fault rule. Here's what that means in plain terms. If an insurance adjuster can convince a jury or convince you that you were more than 50% at fault, which means 51% or higher, for the accident, you recover nothing. Even below that threshold, your recovery gets reduced by your percentage of fault. So if a jury finds you 30% responsible, you only collect 70% of your damages. Adjusters use this rule as a negotiating weapon. They'll find something, anything, to suggest you were partially at fault. You were going 5 miles an hour over the speed limit. Your brake lights were slightly dim. You hesitated at an intersection. It doesn't matter if it contributed nothing to the crash. The goal is to plant doubt, to reduce the value of your claim and get you to accept less. Now let me explain why that matters. In states with pure comparative fault, which means you can recover even if you're 90% at fault, this tactic has less leverage. In West Virginia, where exceeding 50% at fault ends your case entirely, it's a very powerful tool in the adjuster's hands. What your body is doing after a crash. What insurance knows that you don't. This is the part I want you to really pay attention to. After a car accident, your body doesn't immediately tell you the whole truth about what happened to it. Adrenaline floods your system during and after the crash. That adrenaline acts as a natural painkiller. It temporarily suppresses pain signals. It keeps you functional when your body would otherwise be telling you to stop. The result? In the first few hours after a crash, and sometimes for the first full day, you can feel nearly fine, or at least okay enough to think you're not seriously hurt. Whiplash, herniated discs, soft tissue damage, traumatic brain injury. These injuries frequently don't present with full symptoms until hours or even days after impact. Insurance companies know this timeline. They've known it for decades. It is not an accident that adjusters are trained to call claimants in the first 24 to 48 hours. They call you in that window specifically because your body hasn't caught up yet. You're still running on adrenaline. You're still saying, I'm sore, but I think I'm okay. And they want you to say that on a recorded line before your symptoms fully develop. In rural West Virginia, where people are already reluctant to complain, already used to toughening things out, this is especially effective. A Clarksburg or Parkersburg resident who says, I'm sore but I'll be fine on day 1 might be dealing with a $40,000 surgery recommendation on day 21. But they've already said they were fine on the recording. See a doctor within 24 hours of your accident, even if you feel okay. Tell them you were in a crash. Let them document your condition. That documentation is your protection against your early symptoms being used against you. Health insurance rates and medical bill fear. Even West Virginians who have health insurance often face higher out-of-pocket costs and fewer in-network providers, particularly in rural areas. When dealing with high deductibles or limited coverage, the fear of medical bills can push you towards settling fast just to avoid going deeper into debt. Here's what most people don't know. In a personal injury case, your attorney can often negotiate with medical providers to hold billing or set up medical liens, meaning you get treated now and pay from your settlement later. You don't have to choose between getting medical care and protecting your financial future. But if you don't know that's possible, the fear of the bill wins, and you settle for whatever the insurance company offers just to make it stop. So what do you actually do if you've been in a crash in West Virginia? First, don't give a recorded statement to the insurance company before you've spoken to an attorney. You're not legally required to. If they tell you otherwise, that's simply not accurate. The adjuster works for the insurance company, and their job is to protect the insurance company's money, not yours. Number 2, get medical attention within 24 hours. Even if you feel mostly okay, your body may continue to reveal injury symptoms over the following days, so don't wait to see a doctor. Third, document everything. Photographs of the scene, the vehicles, your injuries, names and contact information for any witnesses. Document the weather conditions, the time of day, all of it. Fourth, talk to a personal injury attorney before you accept anything. Consultations are always free. Most personal injury attorneys, including our firm, work on what's called a contingency, which means you pay nothing unless we recover money for you. There is no cost to finding out what your case is actually worth. Sandra didn't know any of this. She took the $4,200 because it was what was in front of her and she was scared. Her case was worth significantly more than that. And once she signed that release, there was nothing left for her to do. Don't be Sandra. If you want to go deeper on this, I'll put together a video specifically on what insurance adjusters don't want you to know, the exact tactics they use, and how to recognize them in real time. Watch that one next. The link is right here. And if you've already been in an accident and you're not sure where you stand, call our office. The conversation costs you nothing.